Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, Dr. Suzanne Bechtel here again, continuing my series of lectures on contract law. This lecture covers the key concepts and rules regarding consideration in contract law. We're going to explore fundamental concepts and legal principles surrounding consideration in contract law, examine its definition, and various types of invalid consideration, and important rules like the pre-existing duty rule and equitable remedies, such as promissory estoppel. So we'll cover these points, the requirements of consideration, what is considered invalid consideration, pre-existing duty rule and its exceptions, some areas of sufficiency and fairness of consideration, and we're going to look at promissory estoppel and special agreements, including accord and satisfaction. Essential elements of considerations in contracts will be covered next. So as we continue with the topic of contracts, consideration is super important. It goes right after offer and acceptance, so thus we're covering it now. The first two elements are offer and acceptance, and that will allow for a legal contract. The third element of them all is to have something called consideration. This is essentially the subject matter for which the parties are negotiating for their contract. And oftentimes this would be goods and money or service and money. Oftentimes our money is going one way in that it's also referred to as the bargain that supports the contractual relationship. It's got to be something of real value to count as consideration. And what that means is it doesn't have to necessarily be a specific monetary value, although usually you can tie it to that. It can be something called a benefit, whether either you are the party who confers the benefit that you give someone else or a detriment that you incur for yourself. So the concept of consideration can get a little confusing, but hopefully we can clear that up as we go through the topic of consideration. One of the things that's important with consideration is both parties have to be giving consideration. They've got to be giving something of value. You can't have one person giving and the other one not. So what does it mean by benefit conferred? That could be exchanging or giving to someone else, some object, some goods. Some are doing a service for them, like detailing their car, doing cleaning services, teaching services, legal services, and of course money. And you know all those things would be a benefit that you are giving to the other person. And what you mean by incurring a detriment means you're giving up something. But it's a legal right. You're giving up a legal right at the request of the other party in exchange for something of value. And the most common situation like this would be a liability waiver. If you've ever gone to participate in something like zip lining or parasailing, jet skiing, things like that, chances are you signed a waiver and the language in there said, you know, you are giving up your legal right to sue the business that is providing the zip lining course in exchange for something of value. And there's something of value, meaning exchange for them letting you come to on their property and let you zip line and provide the zip lining you need and the services and equipment and all that other whatnot. You were agreeing to give up your legal right to sue them should something go wrong, and that means you've incurred a detriment. You're giving up something you don't have to do, and that's common. Another common contract where there is a detriment incurred is when a client or person settles a lawsuit and they sign a release. And the release says, in exchange for the money that you're paying me to settle this case, I'm giving up my legal right to sue you for negligence for this car accident or for breach of contract or something like that. So those are two common scenarios where you would have a detriment incurred. Now we've talked about what consideration is, and let's talk about some of the things that are not consideration, that cannot count as consideration. So ask yourself, what is past consideration? What do we mean by past consideration? As if you've already obligated to do something you've already agreed or promised to do in the past, or agreed to give something in the past. You can't use the same thing to serve as consideration in a new contract. You can't recycle. So exceptions and non-considerations do exist, as always, in the law, including past consideration, moral obligations, gifts, illusory promises, and pre-existing conditions. And we're going to go through these in these topics. When looking at whether consideration exists, you have to be careful. You need to ensure that, as I've pointed out twice already, whether consideration exists, whether one side is doing all the promising and giving and the other side's just simply receiving something. If that's the case, that's not consideration, so it's not a contract. We'll be going into the pre-existing duty rule in a couple of slides from now. But it's an example that seems to come into play at this point. Good point to at least bring it up and introduce it. But if you promise to do something you already have to do, it's not consideration. Types of invalid consideration. Past consideration has limitations. Moral consideration and legal insufficiency, gifts and illusory promises as non-consideration will all be covered in this short section of this lecture. I've got the picture of a firefighter here because one of the typical illustration stories we use for this concept of pre-existing duty rule is your house is on fire. I hope not. The fire department comes and you tell the firefighter that you have got this really valuable stamp collection and that you'll pay $1,000 if you save the collection in the house. The firefighter says, oh, okay, I'll save your favorite stamp collection, or at least I'll try. And they do. So the question is, are you now do you now have a contract where you have to pay the firefighter that $1,000 that you promised them? And the short answer to that is no. And the reason why is essentially you made a promise and you offered that your consideration was $1,000. And that's fine on your part. The consideration fails on their part, the firefighter's part. The firefighter is agreeing to go in and help save property. He's already obligated to do that as part of their job as a firefighter. So that's not going to count as consideration. So we would not have a contract there. You might feel morally obligated on your end and that sort of thing, certainly, but it isn't makes personal sense perhaps. But it's not consideration because they were already bound to do it. So there's some exceptions we need to talk about. If there's a new or different consideration given, if they change, give new consideration, then that is fine to form a new contract. If the purpose is to simply ratify obligation, you remember we talked about the fact that you're minor, under 18, you enter into a contract, and of course since you're a minor, it's avoidable. But let's say you turn 18 and you want to continue on with the contract. You could say that you want to continue on with that, and it's the same consideration, so nothing's changed. So technically, that would be something you're already bound to do. But because it was voidable and you could get out of it, you could have avoided it if you chose, but you chose not to. And that's a deficient consideration. So there's an exception there, and the contract will be good. All right, let's look to moral consideration and its legal insufficiency. So moral consideration refers to promises made out of gratitude, kindness, or sense of moral duty, but not as part of a bargain for exchange. Contract law requires that each party gives something in return for the other's promise. A purely moral obligation, no matter how sincere, doesn't satisfy this requirement. And courts consistently hold that a promise based on kindness or ethical duty is not enforceable because nothing was exchanged at the time the promise was made. In short, morality may inspire promise, but it cannot create a contract. And although promises based solely on moral duty are generally unenforceable, courts recognize a few limited exceptions where a moral obligation, combined with other factors, can support enforcement. So, if someone owes a debt that's no longer legally enforceable, we've talked about that, because the statute of limitations has expired, a new promise to pay can be enforceable even without new consideration. And the rationale behind this is the original debt creates a material antecedent obligation, and the new promise revives it. So, just simply saying, I know the debt is old, but I promise to pay you back, is enforceable. There's another one called the Webb versus McGowan exception. And this applies when the promisor received a substantial material benefit. The benefit was not a gift, and the promisor later makes a promise to compensate. So a worker saves his employer's life at a great personal risk, and the employer later promises to pay him in a monthly stipend. And the court may enforce the promise because the benefit was extraordinary and non-gratuitous. This is sometimes described as moral obligation plus material benefit equals enforceable. Pretty easy little formula there. If someone promises to perform a voidable obligation, if someone makes a new promise to perform a duty that was voidable, and we go right back to our 17-year-old making a contract, the new promise can be binding. So I won't work that in anymore. I don't even need an example. Promises to pay for past support in family situations. So this is rare. Some courts enforce promises to pay for past family support or necessities, especially when the promisor had a legal duty at the time or the promise event prevents unjust enrichment. And this isn't universal, but it appears in some jurisdictions. Again, rarely. So you need to see that contract law is not purely rigid. It balances bargain theory with fairness and policy. So that is the moral consideration topic. Moral consideration alone is not enough, but when a past legal duty or a substantial material benefit exists, the law sometimes enforces the promise anyway. Next, gifts and illusory promises as non-consideration. So both parties, again, have to be giving some consideration. They've got to be giving something of value. Without the consideration and the other aspects of contract requirements, then we won't have a contract. So illusory contracts are those that just kind of, they're the ones that really kind of up in the air. They're not specific. And I do have some examples coming up of that later in the lecture. Next, we look at pre-existing duty rule again, and simply for the sake of discovering a little more on its exceptions. An illustrative example will be given with the firefighter again and some exceptions. So we've gone over the rule. Now let's move on to the exceptions of it. Recall the foundation of the pre-existing duty rule is the point that you're saying, I've agreed to do that already, so that promise I'm making isn't going to count as consideration. And with that, because I've already been obligated to do it. Now there are exceptions. We need to talk about them. If they're new or different consideration is given, if they change, give new consideration, then that's fine to form a new contract. If the purpose is to simply ratify an avoidable obligation, remember we talked about that with the 17-year-old affirming the contract after turning 18. Unforeseen circumstances that will make a duty more difficult to fulfill. It might be an exceptional pre-existing term rule if something changes and that's going to be much harder to do it. I promise to do it this way even though the circumstances have changed and become much more difficult, that the promise may be sufficient anyway. All right, some if truly unanticipated difficulties arise after the contract is formed and the modification is fair and equitable, courts may enforce the new promise. And for example, a contractor encounters unexpected subsurface rock that dramatically increases the labor to perform their service. A reasonable adjustment in price may be enforceable. If the party promises to do something extra, different, or beyond the original duty, that new performance can serve as valid consideration. Finishing the job earlier, or adding extra work, or providing upgraded materials is an example. If both parties agree to cancel the original contract and enter a new one, the new promises are supported by fresh consideration. It works because each party gives up rights under the old contract, and this counts as consideration. And then there is, again, the UCC, and the UCC has a modification rule for goods contracts. Remember, this is for sale of goods between merchants. A modification to a contract for the sale of goods is enforceable without new consideration as long as it's made in good faith. And this is a major departure from the common law rule. And we talked already about settling a dispute, but in terms of pre-existing, how do we look at that as an exception? If the parties genuinely dispute the amount or terms owed, a promise to accept a different performance is enforceable. For example, a creditor accepts a lesser amount of good faith dispute over the debt. People negotiate the debts all the time. Reliance, which is another promissory estoppel quality of, is where one party reasonably relies on a promise to modify a contract. An injustice can only be avoided by enforcing it. And the courts may uphold the promise even without new consideration. For example, a subcontractor relies on a promised price increase to hire additional workers. And third-party promises, additional compensation for the same performance. That promise is enforceable because the duty is not owed to the third party. So to just wrap this topic up, when there are unforeseen circumstances, new duties, mutual rescission, UCC good faith modifications, reliance, settlement of disputes, or third-party promises, we might have an exception to the pre-existing duty rule. So how does the law approach sufficiency and fairness of consideration? So we're going to look at the law's approach to fairness and consideration. We'll take a gander at caveat emptor and caveat venator principles, sham consideration, and its legal implications. Okay, because a lot of times people say, well, you know what, if you made a bad deal, shouldn't you be able to, get out of that because of the consideration? And what if you agree to pay $500 for something that's really only worth $10,000? Well, unfortunately, I'm sorry, we're only worth $10. I'm like, wait, why is that hitting me right? Well, unfortunately, or fortunately, whichever side you're on, the law is not really concerned with whether you made a good bargain or whether the terms of the contract are fair. Consideration requires a real exchange, set it and set it and set it, past areas, optional obligations, purely moral, or a gift does not count. So several types of promises fail as consideration because they do not reflect a true bargain for exchange. Here are the four most common categories: past consideration, moral consideration, illusory promises, and gifts. So, past consideration refers to a benefit or service that was already given before the promise was made. And because the act wasn't done in exchange for the promise, it cannot serve as consideration. For example, a student rescues a professor's laptop from being stolen. Grateful, the professor later says, "I'll give you $200 for what you did." And the rescue happened before the promise, so no bargain was made and there is no contract. If it's already completed, it cannot be considered for a later promise. A promise based solely on a moral obligation, a sense of fairness, gratitude, or duty does not create a binding contract. So if your neighbor says, "You've been kind to me, I'm leaving you $5,000 in my will," the kindness was not bargained for. The promise is made on moral duty, not legal consideration. And morality alone does not create enforceable obligations in contract law. An illusory promise looks like a promise, but it's not actually something that binds a promisor to anything. If one party retains unrestricted discretion to perform or not perform, there's no commitment. And an example of an illusory promise is something like, "I promise to buy your car if I feel like it." The promisor has complete freedom to perform or not. There's no real obligation and there's no consideration. And a promise that leaves performance entirely optional is not a promise at all. And again, a gift is a voluntary transfer. So whether grandma gives you the $1,000 for your birthday that grandma said she would give you, it's a gift, not a contract. And a promise to make a gift is not enforceable because nothing's bargained for. Okay, I know we've looked already at caveat emptor and caveat venator. But I want to focus in this slide on, although we know these phrases and what they mean, buyer beware is caveat emptor, and caveat venator, that covers the seller beware. But caveat emptor and promissory estoppel operate in tension with one another. One pushes responsibility onto the buyer, the other protects the party who reasonably relies on a promise. So understanding how they interact will help you see where our modern contract law has shifted away from strict formalism toward fairness-based doctrines. So we look to equitable remedies. An equitable remedy is what the court can do if the legal remedy would be unfair. And here's the promissory estoppel in a nutshell. You have a situation where one person reasonably believes they've entered into a contract when actually they didn't, because whatever reason, consideration, something like that, has failed. There's not really consideration there, but one person believes, "Hey, I got a contract," and so they go on and act and do things, spend money and time and thinking that they're under this contract, so they rely on it. And then they find out at some point there isn't a contract because there's no consideration. Well, the court may enforce the promise up to that level of reliance. If the promise they can show they made was reasonable, the court can rely on that. So they can say, under the circumstances, it's reasonable to see why you might have thought you had a contract. And let's say it was one for, a painting. For painting a house. Sorry, I had another example of a different type of painting. I can paint my house. Such and such, and you don't actually own the house. It's not your house, or something like that in the promise. And the promise believes it to be true. The promisee believes it to be true and believes there is a contract and goes out to buy supplies and things like that, only to find out they can't paint your house because you don't own the house. A lot of contractors are very, very careful about this. They even interview both. If there's more than one person living in a home, they'll ask them both to sign the contract. So essentially it's designed to even things up again and put them back in the position where they were before. But again, you've got to show that you had a reasonable belief that a contract existed. All right. Next, let's look at sham consideration and its legal implication. Sham consideration is a false or pretend exchange of value, something that is written into a contract but never actually paid, promised, or intended by the parties. It's a pretense. It's not a real bargain. The parties do not intend the stated consideration to be real, and courts look past the written words to the actual conduct and intent of the parties. If you went to Corbin on contracts, you would see an explanation that sham consideration occurs when the contract recites that something has been paid or promised when it has not. The contract supported only by sham consideration is generally unenforceable because there's no real bargain for exchange, which is the core requirement of consideration. Courts will treat the agreement as lacking legal intent or as a sham contract, meaning it was never meant to create legal obligations. Sham contracts, including those with sham consideration, are unenforceable because the parties never intended real legal obligations. So an example, sham consideration is like writing, I paid you $10 when both of us know I didn't. And the courts don't enforce pretend bargains. They enforce real exchanges, and it's important to grasp this quickly. And nominal consideration. So we have real consideration, even if it's small. Nominal consideration is paid but not bargained for. And sham consideration, never paid, never intended. Next, we're going to look a little bit more deeply into promissory estoppel, the requirements for promissory estoppel to apply, give some examples of reliance, and also court enforcement. So the definition of promissory estoppel, it's a legal doctrine that allows a court to enforce a promise even when no formal contract or consideration exists, if the promisee reasonably relied on that promise and suffered detriment. And the doctrine exists to prevent injustice. Courts use it to stop a promisor from backing out of a promise when the promise was clear, the promisee reasonably relied on it, the reliance caused real substantial harm, and only enforcing the promise will avoid injustice. It's an essential area of law in contracts. It fills gaps where no contract technically exists. It protects reliance interests, not bargain interests. It prevents unfair outcomes when someone changes position based on a promise. It limits the strictness of the consideration requirement. So let's say a grocery chain promises a man that if he sells his bakery and moves to a new town, they will give him a franchise. So he sells his business, moves, and spends money preparing, and then the company backs out. Even though no formal contract existed, courts may enforce the promise because the promise was clear, reliance was reasonable, and the harm was substantial. And not enforcing it would be unjust. So lastly, we're going to look at special agreements and accord and satisfaction in contract disputes. Accord is the new agreement in which the parties decide to accept something different from what was originally owed. And if you look this up on various places on the internet, you'll see that it's an alternative performance and it discharges a pre-existing duty. So the satisfaction is the actual performance of that new agreement. Once the alternative performance is completed, the original obligation is discharged. And this allows parties to resolve disputes without litigation. It replaces the original obligation with a new one, and once the new terms are fulfilled, the old claim gets extinguished. and it's used a lot in debt disputes, especially when the debtor offers a lesser amount as payment in full. So in accord and satisfaction, they change their original contract and agree to forego a lawsuit. And that's fine, they can do that. We want to encourage them to do that, even though the consideration is essentially the same. It might not count as past consideration in this situation, but if the parties have a disagreement, they modify the original agreement and agree to forego litigation. And the courts like that. So that would be fine as a part of satisfaction. And you should check, and there's some good studies in the textbook. So, concluding, consideration is a vital element, ensuring contracts are binding and fair. You need to understand its requirements, limitations, and related doctrines like promissory estoppel and navigating contract law effectively. So that's it. Thank you.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.